on behalf of myself, but for the other tenants.
I denied the motion.
You denied
You're
the
all
fact
set.
that I can't talk. I pay you when I get paid.
For the record, I do apologize. I'll be with you in just 1 second.
I don't know. It doesn't even, their ledger that they sent me doesn't even reflect that. As she
do you
said,
get notice when they, with the registration, do you get notice when it's received by them?
no.
I thought you were sending
I have a return receipt request, yes.
You don't get it back?
I don't get anything from them. I get
No, that's what I'm saying. You get something from the post office that says when they delivered it?
Yes.
Okay, is it being delivered before the 5th or by the 5th?
No.
It's being delivered after the 5th?
Sometimes not.
Okay. Okay, counsel, did you want to respond?
I believe that these are late fees.
$1,000 in late fees?
60063.
Judge, actually, if you could just bear with me for one more quick second. I'm just going to tell this. I'm being called into another courtroom that I'm on the record with you. I apologize.
It was at this moment that she knew. She fucked up.
It doesn't sound like you told them that you were on the record. It sounds like you're handling another court case while you're on the record in my court case.
I am not, Judge. He just called the case and we just placed appearances on the record. I do apologize. I'll be with you in just 1 second.
1 minute, 37 seconds later.
And then, of course, they'll bill both clients separately, get paid double for the same time.
Judge, I apologize. I did tell the judge that I was on the record with you. He just called the case and I placed my appearance on the record.
But you were clear that you had more than one case at 2 o'clock today?
No, Judge. This case was actually scheduled for 1:30 and he just called us at 2:15. But I did put in a request for another attorney to take over the case in the 40th district.
Thank you.
Absolutely.
Okay, so this motion was filed in November. The amount that it said was past due for late fees was $450 plus a statutory attorney fee of $75. How did we get from that to $1,000?
Judge, there was another late charge assessed February 6th. January 16th, January 6th, December 16th. Once, like after, they have a grace period of 5 days, and then one is assessed the 6th day, and then one is assessed again after, I believe, 10 days after that.
That sounds ridiculous. Let's see here. And $100 late fee on top of a $50. $150 in late fees a month? It's excessive. No?
Judge, it's contractual. He did agree to it under the lease term. If the court caps late fees, we would be happy.
For the lease. I'm looking for the lease now, actually, if it was filed. Did you file a copy of the lease with your motion?
With the J2, 402, yeah, I believe that we did, Judge. It would be exhibit number 1 to the lease. To the motion. I'm sorry. Do you want me to wait for him to finish, Judge?
What else did you want to share?
At this time, I'd like to form a countersuit for damages.
You don't do that on the record.
And mitigate
Sir,
damages.
that's not how this works. If you want to file a countersuit, you go down to the civil department and you file a countersuit, and then you have to serve them on it. You don't do that in the courtroom.
Right. I have paperwork for them right here.
Yeah.
I have everything that's required.
Again, you have to file a countersuit first downstairs at the civil department, and then you have to serve the other party with the countersuit.
You're correct.
So
And I was told I could do it here.
you cannot do it on my record. Okay, but they at this point are aware that you intend to file a countersuit. It doesn't appear that you filed it yet.
No, because I was told I could do it here. So I've
Who
been
told
waiting
you?
for this.
Who told you you could do it in the courtroom?
A lawyer.
There's no licensed lawyer who should have told you that, because you don't file anything in a courtroom. You file complaints at the clerk's office. So you can file your counter complaint, but it has to be downstairs at the clerk's office, and then you still have to serve the other party, okay?
Yes, ma'am.
Is there anything else relative to the motion?
Yes. At this point, I'm motioning to request a whistleblower status from
Okay.
this court.
Well, let's stop here. Before you file another motion, because that's what you're trying to do now. Can you address the motions we already have pending? We got 2 motions today. Anything else on these motions?
I've already addressed those.
Okay, well then you hold that for now, because I'm trying to close out these motions and then we'll get to that. Counsel, did you want to respond to the motions that are already pending?
Yes, Your Honor. With regards to what the defendant said about Section 8 payments, their portion is not late, nor are the late charges because of any Section 8. It's his portion that is consistently paid late, Judge, and that is the late fee that has been incurred from defendant's portion's late payment. So I just wanted to clarify for.
He stated a defense to that. He says that he had an agreement with someone that was identified as a leasing agent, that he could pay this later. Now, it's now up to you, though, to prove that. I'm just denying their motion today, but the case continues. You now have to prove your defense at the trial. You would have to show, based on your evidence, that there was somebody that you spoke to that agreed that that was okay. Or they're going to show that that never happened. You understand that?
Yes.
Okay. So as it relates to that motion is denied. Your motion is also denied, your motion to dismiss, because for the same reason. You all are on opposite ends. So when one person says something and the other person says the opposite, it just creates a question. I can't grant it, because you both are saying something that could be true. And it's reasonable. Now we got to go and you present your evidence, and I can determine based on your evidence which one I believe is true. So I'm denying your motion to dismiss as well. You want to go downstairs and you want to file a counterclaim. They have paperwork, or should have paperwork, for you to do that downstairs at the Civil Department on the 5th floor. And then you can serve the plaintiff through their attorney, which should be on your paperwork, okay?
Judge?
Yes.
Would you like me to draft an order?
Yeah. It just wouldn't be entitled a counterclaim. Anything else, sir?
Yes. Yeah, I'm under a lot of pressure, so I'm not thinking completely clearly. This is the 4th time they've tried to extort money from me. The other 3 times, according to their own paperwork, they were defeated and unable to do it. This is the 4th time, and they do this to other tenants in my building. They make as much money as they make in rent on extorting late fees and all kinds of made-up things. So I'm here not only on behalf of myself, but for the other tenants, that we're all poor and unable to hire lawyers and get things done in a correct way according to the court. But I did find a lawyer who said it's not a brief. He filed that paperwork that I submitted. It says under Section 8, the rules of Section 8 does not permit for late fees. And telling the fact, I've told these guys many, many times, I pay you when I get paid. It says it can't be a late fee on the mail. And
I recognize that what you're telling me is that you told them that, but let me let you know how rent works. You don't get to tell the landlord when you're going to pay rent.
I do.
Now, no. Just like you don't get to talk over me when I'm talking. You don't get to tell the landlord when you're going to pay rent. You do, and you and your landlord do get to come to an agreement about when your rent will be due. But if the landlord said rent is due on the 1st, you don't get to say, I'm not paying it on the first, and then that just becomes the rule. You have to get them to agree. And what you're telling me is that there was an agreement, so now you have to prove that there was an agreement. If you're not able to prove it, if all you're able to tell me is that you told them that you weren't going to pay it by the 5th, that's not going to suffice. Do you understand that? You can put your hand down. I'm not done yet. The other thing is you do not have standing to be here on behalf of everybody in your building that you believe was wrong, unless this is a class action suit, and it is not. So you are here on behalf of Mr. Robbins. You understand that?
Yes.
Okay. So you can feel free to go downstairs to the 5th floor and file a counterclaim or a whole separate lawsuit against him if you believe that you've been wronged in some sort. You file your complaint. You should make sure it comports with the court rules, and then they will respond and take it from there once they're properly served.
For the record, I do apologize. I'll be with you in just 1 second.
I denied the motion.
You denied
You're
the
all
fact
set.
that I can't talk.